Growing digitalization and data use have made it necessary to have in place a legal framework that recognizes both the rights of the individual to protect her personal data and the need to enable its lawful processing. For this, Parliament has enacted the Digital Personal Data Protection Act. This talk aims to introduce its key aspects. So the way we've tried to organize things is what is the state of the law today as it obtains, a broad understanding of the Act, then comes the interactive part. Fifth is not really there, that's towards TPDP readiness. A final slide on just some steps that you can do, start doing right away perhaps, and those are some thoughts for all of us. So this is just a survey of this existing law. Today data protection is there by virtue of the rules made under the IT Act. Those are called SPDI rules. They apply to companies and other bodies corporate, including government companies, but they do not apply to government itself. So today government is outside the purview of data protection, but private sector and government companies are, and those are in the SPDA rule, although this is a very skeletal framework compared to what the DPDP Act represents. And beyond that, just to remind us all that this isn't the only source of law on the subject. There is sectoral law, contextual law on various things. So there is customer and payments information on and then there are taxation laws, statistics collection, Statistics Act, the POCSO and the Prevention of Sexual Harassment Acts. This is for victim protection. Drugs and Cosmetics Acts protects drug trials, mental safety and Surrogacy Act, they protect patient information. IPR laws protect intellectual property. Disclosure of wills is barred under Registration Act. Telegraph Act protects subscriber information. RTI also protects for personal information and various other classes of disclosure exempt information. And an Aadhaar Act protects Aadhaar information, and this list is by no means complete. And these acts are there, and we'll also dwell upon what happens. These acts are there and what really happens with regard to these acts, and there will be more such acts even in the future. So what we have is the journey really begins on this legislation in a big way, although there was a 2011 bill also on data protection and data privacy. But 2017, the Supreme Court in the interim judgment in the Puttaswamy matter held privacy to be integral to the fundamental right to life in Article 21. And then there was at the same time a committee constituted by MITI, and as an outcome of all that, there was one bill, and finally there was a second bill, which was first bill was withdrawn and a second bill, and that was got enacted in and published after assent of the President in August 23. However, the act is yet to be brought into force, and the rules are also to be notified after public consultation. The intent of the government has been repeatedly stated that the way this will be done is that there is adequate time given for compliance, and therefore notifications of different provisions of the act and of the rules would be done in a manner which would enable that. And section 44 of the act would repeal the parent section under which the SPDA rules are made. So therefore, as and when this comes into force, SPDA rules would effectively stand repealed. So this will substitute those. On the act itself, the broad aims of the act are, it's a bit distinct in the class of legislations across the world, as was publicly acknowledged by the government while doing public consultation. We took a look at other laws also, most importantly the General Data Protection 2016 of EU and various bills in other places. We took a look at those. All of those have a sole purpose, which is to protect and secure personal data. In this case, this act also says at the preamble itself and to enable its processing. So it is both a protection and an enabling law, and for that it's ensuring ease of doing business, bring about law, bring about responsibility, but without impeding ease of doing business, without disabling digital governance, which is critical to a developmental context like India in particular, lay a future ready framework for India as a whole, for the digital economy as a whole, and for innovation, and then minimize the compliance for the innovation system while protecting the users. So these are the key design objectives of the principles of this act. In terms of principles, the principles are no different from what they are in any other act. It's the design which differs. These principles are common to this class of legislation across the world. Lawful and fair use. Fair means with consent, transparent and all that. Purpose limitation, that means if whatever purpose you've taken the data for, you use it only for that purpose and not some other purpose. Data minimization, take only as much data as is necessary. Data accuracy, if you're going to use my data to take decisions that affect me, please ensure you have a responsibility to make sure that this is accurate and updated, and I do not suffer with the way you maintain data. And storage limitation, keep data as long as is necessary, not beyond that. And then reasonable security safeguards, a responsibility to take all reasonable steps to keep it safe. And finally, accountability for all of the above. So these are very simple principles. This is the heart of what is expected. And as we go down this interaction, you will find that actually, in many ways, this is about all that the Act says. And it doesn't say much more, but we'll see. The law was an attempt to be a Saral law, simple, accessible, rational, and actionable. It's fairly short. It was half the previous length of the bill. If you compare with other bills like Australia, GDPR, etc., it is barely in length, about 15%, 10 to 20% of the length of the other pieces of legislation. It has been written in a style where you can read it yourself. It's a very short piece of legislation. I would encourage each of you to simply go to the website. If you Google, you'll get the first search result on the MeitY website. Just glance through it, and in all probability, you should be able to understand it yourself without the help of any legal department or anything. And the reason is that we've gone back to the old best practice of all of you have seen IPC, CRPC, Contract Act, Evidence Act. There are illustrations, examples given, cases. If A does this, B does this, then what happens? And we have avoided this, that first do this, but then provided exceptions and all that, which becomes very difficult for readers, ordinary readers, to understand. So there are no provisos in the Act at all. And even cross-referencing is minimal, that please refer to as stated here in that section, that place. All of that is absolutely minimal. And there is only provision for rules, and the intent is to issue a single body of rules, no multiplicity, and there are no regulations. So the whole body of the law is fairly simple, lean, and designed to be read and understood by the person who's supposed to be protected and the person who's supposed to be responsible in maintaining data. Introducing the aim was also that when we are moving from a stage of law not being there and law coming into being in a society which is very substantially digitalized already, there shouldn't be, life should not be disrupted. So there is processing happening. Pre-existing consent has to be notified to data principals so that they become aware that this data is held and processing is going on. Processing may be done without consent only for certain legitimate uses. So processing is either consent based, but non-consent is only for certain legitimate uses. Enables processing outside India while retaining. So there was this whole debate that if data goes outside India, will it be secure and not? Well, so much of the digital cyberspace offerings are global, so there are no barriers. However, India retains the right to geographically restrict a country or a territory and say there will be restrictions on the flow of data to that. And then there are suitable exemptions, and other laws apply unless inconsistent. So all the other laws that I mentioned and more, they would always apply, and they would only not apply to the extent of any express inconsistency. If there's a contradiction, then DPDP Act prevails. Otherwise, the other law prevails. That said, this Act itself at numerous places says it permits and recognizes other acts. So if it permits and recognizes for the purposes of any other act in the force, law and time being in force, that means that that law is recognized by this law and there is no conflicts. So this law itself recognizes the existence of other laws. It lays down only principles and avoids prescriptive approach and intrusive regulation. There is no regulator who would keep asking you whether you are doing it right or wrong. This is the law. Like consumer protection law, you are responsible for complying with it, observing it. Like civil law and torts, you have a liability for damage or harm caused because of products and services given by you. And it is in the same spirit, you hold data as a fiduciary. That means you hold it in the interest and on behalf of somebody who's entrusted it to you for a purpose. And so long as you abide by that, you have discharged your legal duty. If not, if it is called into question, there is an adjudicatory mechanism. Whosoever feels I have been wrong can go to that, and that adjudicatory mechanism, after a due hearing, will decide whether there is any reason to think otherwise. And there you will be asked to prove why, how do you say you have discharged your duties? And that is where it is. There is no checklist of things you must do this, which is very different from the way, say, the regulated entities today are asked by the regulators to have a long list of things that you must do this. This law refrains from doing that, and there is no regulator and there is no regulation, and the rule making also does not provide for that. The things that are to be made through rules does not cover such things. So it is at the level of obligation, it is at the level of principle. There are no multiple data classes, all data is uniformly protected. So there's no sensitive personal data like under the IT Act or the earlier bill, critical personal data, sensitive personal data and personal data. It's just, if it is personal data, everything is one and everything is equally protected. For the first time in any law, we have a first fully digital by design complaints resolution mechanism, and the choice of it is deliberate. Data Protection Board is to function essentially like a complaints resolution mechanism. It is not intended to function or designed to function like a, conceived as like a court or some other process or a regulator, but an online complaints resolution mechanism. All of us as users, whenever we have an issue, we just click and lodge a grievance in some quarter, and it will work pretty much in the same fashion. In addition, the idea is not to penalize, the idea is to secure speedy justice, speedy remediation, and therefore alternate dispute resolution can be done at any stage right till the final step. And a party which is accused of doing something wrong can submit a voluntary undertaking to the board and say, okay, I shall heretofore not do such things and abide by these things, and therefore with that, that's my commitment. If I don't do, can that matter be closed with that? And it can be closed with that, but then if you violate it subsequently, then there will be no further hearing and you will be charged immediately the way you were originally charged. The penalty will be imposed straight away, there will be no further inquiry. Accountability through monetary penalty only, and there is no criminalization. Other key features, so this is the first parliamentary legislation across the world which uses the feminine pronoun instead of the masculine pronoun. Rights are also accompanied by duties. So we'll see what those are a bit later. Board is in the nature of an administrative body, not conceived as a judicial body, and which will function in an online manner. The first appeal will lie to TDSAT, which too is committed to function by law in an online manner. So TDC in its disposal of telecom disputes would act in the usual manner, but TDSAT acting in the disposal of appeals under this is obligated by law to work in the same manner as the Data Protection Board and dispose of things online. And a second appeal would lie to the Supreme Court. The reason there is emphasis on that text is to bring out that the matter is ultimately going to reach the highest court or may reach the highest court of the land. So please abide by the law. Don't think that just because there is a government entity or those in the private sector who are used to a regulator can grant you forbearance, condone anything. A judicious view would be taken, so it will be, and it's a second appeal means it's a matter of right, it is not an SLP or a writ petition. If a person is aggrieved and not satisfied, they can go all the way up to the Supreme Court. Right. Now, there's a lot of freedom. There's full functional freedom to the fiduciary to determine the manner in which they decide to fulfill their obligations. As I already said, the law will not tell, neither the act nor the rules, what exactly you need to do to discharge your obligations. It will say, this is your obligation. How you do it is left to you. So that's full freedom, and there is no regulator either. But then this freedom comes with the responsibility to read, understand, and meet the obligations, and to establish compliance if adjudicated. So as I outlined, like in a civil law, in torts and all that, nobody tells you what you're supposed to do, what you're not supposed to do. You act responsibly, and if called into question, you explain yourself. Key terms, there are lots of definitions, but digital personal data or personal data is simply data by which a individual may be identified. This is very different from a list approach which is there in SPDI list, which says financial data, health data, biometric data, such and such data is personal data. There is no listing. Any identifiability is the test, either directly or in relation to it. So if you have two pieces of information and they can be put together and you manage things in a manner so that through that a person can be identified, well, that's also identifiability. There is no listing approach, and one has to identify for oneself what is personal data that I hold, and abide by that. Lay down rights and duties of data principal. So data principal is the individual to whom the personal data relates, and data fiduciary is the individual. Three classes basically, while it says legally person, but let's think of it conceptually as individuals. Let's think of it as companies and even private single proprietorship firms and government entities, all the way down to the smallest ones like a panchayat, which process personal data, and it lays down obligations. And data fiduciary can be in the singular if two people are doing it together, jointly determining the means and purpose, then they are both together data fiduciary. And finally, processing is the only term used. There are no collection, storage, no separate terms. All of them are term processing. So mere collection of data, mere storage of data is also processing. And there are rights and obligations and duties around it. The requirements to be met for processing, now we get into the substance of the law a bit. The basic foundation is you can process any data provided such processing itself is not illegal. So if you can't do it for an illegal activity, suppose gambling is banned, you can't process data for purposes of gambling. There is Indecent Representation of Women Act, certain types of data is banned. So an activity itself should not be banned, that data itself should not be banned. Beyond that you can do it. And you can do it only in two cases: default case only with consent, or there is some specified list of legitimate uses, in those cases without consent or only for that use. So consent and notice is the foundation. Consent is not merely that you say I consented. There must be an explicit declaration of what purpose am I asking you to give data for. I must state my purpose and then I must abide by that purpose. So this must be given either simultaneously or earlier. I have given you a notice previously and later you consent, or in the same flow. Consent to be free, specific, informed and unambiguous, and it must be through a positive action. So if you've got a pre-filled consent checkbox is already checked, that's not all right. Consent should be valid only for data which is necessary, and specific would mean things like generally to enrich your experience. Now that is non-specific. You would today find, when you fill cookie consents and so on, such kinds of things, we said, well, those are not admissible because they would not be specific, right? And informed, there must be adequate disclosure. Again, it will not say what constitutes adequate disclosure. You apply your mind and you go ahead and do that. Consent valid only for data which is necessary for specified purpose. So you ask for a bill, you make a purchase, and the person says, I'll give you a receipt only if you give me my mobile number. That's not really necessary. So it goes beyond. So even if you are asked to give consent and you do in fact give a consent and mobile number, the law does not recognize it as consent. It is by law not a valid consent. And therefore any such coerced consent and any processing on that is not protected by law. It will be essentially without consent because it is beyond what consent constitutes. So there must be a direct mapping between the purpose you have stated and the data you are taking. So if you are taking more data, please revisit that you need to define your purpose and this must match. If your purpose is larger, you need to be transparent about your purpose. There is no bar. But you must say that my purpose is not only to sell you goods, but to also this and so on and so forth. So those are things which you will need to say. Consent is withdrawable at any time and this must be with the same ease as that at the time of giving the consent. So you can't make people jump through 10 hoops when it comes to withdrawal. It has to be as simple as the obtaining of the consent. Then we have the certain legitimate uses, so statutory functions of the state and its instrumentalities, and then a notified service benefit certificate licenses by the state if the individual has previously consented for any such service. So this is a unique case where government, if you have taken one government subsidy, benefit, etc. or service amongst a notified class of services, then it need not be taken again and again. All of it is treated as one, and this is there. Compliance with judgment or legal order, protection or assistance or service during a medical emergency, disaster or public order, or to save an individual's life, for employment purposes. And then in relation to employees, we all give biometric attendance and such things, because if you don't have those checks, the employer runs a risk of IPR violations, copyright, corporate espionage, or employee is not really doing the work. So to safeguard employer from potential loss or liability, or for giving them a benefit, you're giving EPF or whatever you will require details for benefit or services. And when the individual submits data voluntarily for a particular purpose, so this is intended to be of the nature when you go to a shop counter and it's happening across the table, and you just say, and examples are given that I'm giving you money and you pay, and there's a digital data being generated in the process. Well, I gave you directly for this, so there is no need in such cases for a full-fledged form, etc. Or you send a WhatsApp message to your real estate dealer, you have just moved into the neighborhood, says asking, please, if you have any rental openings, let me know, and the person sends. Such transactions need not be are treated as implied, but broadly one would say that any place you are having a structured interaction, you have a website, an app, or structured process, then obviously you have to have a proper notice and everything. But this last case will save those kinds of transactions which are just happening episodically, bilaterally, incidentally. Now we come to the interactive portion. So I'll pose a few questions here and we will start. So here is a question. There's a foreigner going through Indira Gandhi International Airport, traveling from Dubai onwards to Singapore, and during that halt uses a credit card, or the second case is uses it at Gift City in the IFSC authority. What do all of you think, whether the act applies only in the first case or the second case or in both the cases? So okay, yeah, we're getting lots of responses. So yeah, different people have different thoughts. Right. So we move on to the answer. But okay, yeah, C, as you can see, is the right answer, and we just see why. So the first thing is applicability is to processing in India. So it may be the international airport or whatever. If it is in the territory of India, and if it is in digital form, it applies. Doesn't matter it's a foreign national, doesn't matter they're transiting. It's happening in India and it's in digital form, so the law applies. So similarly, Gift City may have taxation and other purposes. It's outside for whatever purposes, but it is the territory of India. It applies. Next. Next is a doctor gives you a prescription, and the act applies if the prescription is generated on the computer, like you go to a CG Chase clinic and he'll give you a computer generated thing. Other places you go to a private clinic and he'll give you a paper written slip, and on the way out somebody scans it for record keeping, or you present it at the pharmacy, they generate a record there, they digitize it. So in which cases does it apply? Again, I think pretty much everybody is getting it right. So yeah, you can show the answer. Right. So the point is that it applies also if data is collected initially in non-digital form and digitized subsequently. So which could be a lot of historically government cases where you get application forms filled and they are digitized subsequently. Well, the act starts applying from the time you digitize it. So that's where it applies. So law requires publishing a beneficiary list, and say for example, say Manrega requires you to publish. Now you are to publish it by that law, and there is DPDP now. So do you need to take consent, or do you need to at the outset, or do you before publishing reach out, I need to publish your name, do you agree, or this is not required? In our wisdom, I'll tell you what the answer is. Yeah, it's C. So C is the right answer. And why is it so? So if you look at the law, it says it does not apply. The act itself in its entirety is inapplicable where data is required to be made publicly by law. Other cases are you yourself made it public. Now the stress here is made publicly available. You must, your manner and doing etc. must convey that you intended it to be public. Right? You put something, you go and give a speech in a stadium. I mean, you're making a public act. You can't say, no, take my permission for taking my photo. That's my personal data. I get identified by it. On the other hand, you are going to you are sitting at your say walking down the road. Now, just because I am walking down the road, it doesn't mean that you have a right to simply, take my personal data, take my image, and so on. So it will have to be read with the context, and that is the right way to our mind to look at it. For personal or domestic purposes are certainly out. You share your details with your friend for certain purposes. You are unable to go, you ask your friend, well, these are the details, and please go and pick up my child from there, or so on. Those are personal or domestic purposes. Those are outside, those are not commercial. Applicable to processing outside India for offering goods and services in India. If data is being serviced in India and some data processing is happening somewhere outside India, that too is covered. Yeah. So notice and request for consent should be viewable. You are in a journey. You are online. You are currently transacting in, say, Tamil, and the consent should be viewable in Tamil. Or you are working in Tamil Nadu, interacting with the state government of Tamil Nadu or one of its agencies and department, and let's assume, okay, let's not take Tamil Nadu, let's take another state like J&K, which has two languages, Dogri and Urdu. So all the service languages, even though you may be in the service flow on Urdu, but you should also have an option to view it in Dogri, or you need all 8 scheduled languages, all 22 of them in English. So the answer really is C. Even if your platform or service or application is not in all the languages, it has to be offered in all, irrespective, because, and this is limited to not everything, it is limited only to notice and request for consent. The spirit of it is that consent is like, you must know what you are giving, you must be able to read and understand it. What you do subsequently, you can take assistance, but it is like, otherwise, consent is like angutha laga diya. You're just taking a thumbprint without understanding anything. So you must be able to view it in every language. Next. So pre-act consent-based processing may continue. Now, how will it continue? Only after obtaining consent afresh, once the act comes into force. You are already processing data as a department, or only after giving consent of such a notice of such processing. I tell you that I already told you, you have to, that slide I showed you, you have to give a notice of pre-act consent-based processing, or unless the consent is withdrawn. Okay. The contest is still on. Yeah. So the correct answer is, of course, C. And the reason is as follows. Both are required. Notice is required to be given, and it is to be required to be given as soon as practicable. No time frame has been given. The reason for that is we have today not categorized or flagged our data as personal data in our databases. Many of us in government offices or elsewhere may not even know what is or isn't a personal data, what data I hold or don't hold, and then may not have readily archived the consent, etc. also. So it's a bit indeterminate. At the same time, as soon as practicable does not give you a free pass not to do it or use it as a pocket veto, because there is the data protection board with a hierarchy of appeals above it, remember, and if you take too long doing it, surely somebody will go and raise an adjudication. It's been a year, 2 years, and you've done nothing, and what are you going to? You'll be asked to take a stand, make a submission in a hearing, and then somebody else will decide whether what is it practicable or not practicable, have you done enough or not done enough. So yes, on a best effort basis, as early as practicable, you should give notice and do that. But processing may continue unless consent is withdrawn, and the two are not linked. So it is not sequential that this has to happen first or that has to happen first. So processing, unless you withdraw, it continues. Now here is the next one, and this is very typical, and both sides of the story are here in this actors in this game. There are departments here and there which are government agencies and which process. Now in this case it could be a processing. You engage some, take for example the Indian Banks Association, which engages the IBPS to carry out their examination. How can you engage the candidate? How can you engage this? The nature of the relationship, you issue an executive letter, you execute an MOU, you execute a contract, you can execute an MOU or a contract. Okay, so almost nobody got it right. I think maybe 1% did. So the answer is C. MOU will not do. The reason is that there has to be enforceability. When this law says only the so how will you enforce it unless there is a contract? An MOU, as we know, is not legally enforceable. So short of a contract, nothing works. Right? So there has to be a contract. Yeah, so this is the next is data breach has occurred. Now, who should it be reported to? The Data Protection Board of India, certain, the affected persons, all three. Okay, so right answer, almost everybody got that. It has to be reported to all three. But the interesting thing is, this is again materially different from all other this class of legislations in other countries. In other countries, there is some leeway and discretion, some materiality thresholds and so on. In the Indian Act, each and every instance has to be reported to the affected person as well, not just to the Data Protection Board, and irrespective of materiality. If a breach has happened, you have no choice but to disclose it. So here are some of the other obligations of data fiduciaries: intimation of the breach to data principals and Data Protection Board, reasonable security safeguards, implement technical and organizational measures to ensure compliance. So you enter into that contract for that selection agency, and you say, okay, legally they are obligated, but well, you still have the responsibility to have reasonable technical and organizational measures. You can't outsource compliance. It will continue to be your responsibility. Ensure completeness and accuracy of personal data. Erase data when no longer needed for specified purpose. Establish effective grievance redressal system and publish contact details for answering queries, not just on grievances, but even on consent, etc. So there's a government IT agency which manages a department's app, and the app has personal data which is non-compliant. Who shall pay the penalty? Yeah, so it's the department. The responsibility ends with the data fiduciary. You can show, yeah. Data processor, this act does not hold liable. If you have a contract, through contract you can hold the vendor or agency liable. You can recover costs or whatever, or if it's a government agency, seek disciplinary action, whatever else. But the liability would rest with the department. The data processor, in fact, is not recognized. It is permitted but not recognized for any penal purposes. It's not even part of the hearing. It's not required to be heard. Imposition of penalty by the board. Penalty is imposable only on data fiduciary, and this is it. Processing of children's data, there are certain bars here. Processing can only be done with the consent of the parent or legal guardian. No processing may be done which is detrimental to children's well-being, and children may not be tracked or behaviorally monitored or targeted, and child is anybody below 18 years of age. However, there is a provision that through prescribing, through rules, certain types of prescribed cases, processing may be allowed without parental consent, or even monitoring tracking may be allowed. So, child is there in the orphanage or is under care or whatever else. This is intended to cover all classes of cases where such without consent processing or tracking, etc., would be essentially in the interests of the child. So it would basically cover those cases. Rights of data principal, right to access information. This is access information, not literally in the sense that access the entire copy of the information. It is more correctly right to know about information held. And this right is not like a roving right like in RTI where I simply apply and ask for anything. This applies in relation to a data fiduciary with whom I have had a previous transaction. So I cannot simply approach an office and say, tell me what all data you hold with me. I'll have to identify my previous transaction. I'll have to say, this is there, and now tell me the details of what processing you have done with this and who else you have shared it with. That will have to be disclosed. Similarly, right to correction, update, etc., and erasure of personal data. And then there is right to grievance redressal and right to nominate another person. Data is held, the person dies. You have a right to have a nominee. You cannot not provide for a nominee for a successor, for in a sense my digital successor, right. Duties are also there. So duty is to comply with applicable law while exercising the rights, to not impersonate while providing data, to not suppress information while providing data for in relation to government. Because government data is relied upon, you cannot suppress material information, to not register false grievances or complaints, to furnish verifiably authentic information while exercising right to correction or erasure. This is to prevent fraud. And if there is a violation, the board may impose a penalty of up to rupees 10,000. So here is a case, somebody gets treated in a private hospital empaneled under the Pradhan Mantri Jan Arogya Yojana, which is administered by the National Health Authority. And the person subsequently post the treatment says, please, I withdraw my consent and also erase all my data. And he asks both the private hospital and NHA to do so. Now, what is to be done? Both of them erase all the data, and both stop processing, and the hospital erases the data, and both only stop processing. Yeah, it's a tough one. It requires a specific knowledge of the law. So right answer is B. Okay. So why is it B? Let's just see that. And yeah. So state and instrumentalities are exempt from right to erasure. The reason is that state is publicly accountable, and accountability of the state would break down if you just erase data. Similarly, enforcement would break down. I commit a subsidy fraud, I just erase. No accountability would be possible. So erasure is not a right, either in terms of obligation or in terms of the rights. It is the state and its instrumentalities are exempt. And that said, it would still be a good idea for the state, if you don't need data, delete it, because data will come with all these liabilities and responsibilities and work attached to it. So you are not required to erase, but it would be certainly a best practice for you to erase what you don't need. Next. So there is a RBI regulated entity, and it is asked by RBI to give it information, and that information includes personal data. So what should the regulated entity do? Should it give the data to RBI? It should not give. It should give after seeking consent, or give it after redacting the personal data in the information. Okay. The first one is the right answer, and the reason is exemption from, so performance of judicial, regulatory and supervisory functions under law by a body established by law, it is exempt. Enforcement of even civil rights and claims, even that is permissible. And prevention, detection, investigation, prosecution of offences or any other contravention of law, not only a criminal case. Violation of the law, that is also permissible. It is carrying out drug testing trials, and it is say doing it, there are these ethical guidelines, standards, etc., which are there for clinical tests. It is abiding by those. So what happens here? Is it exempted, not exempted, such personal data? Yeah, so the right answer is the middle one. It is exempt if prescribed standards are complied with. So this is for research, archiving or statistical purposes. There is an outright exemption, and it is available to public and private entity alike. But there are qualifications, so those are there. The instrumentalities of state that may be notified. So this is akin to what you are saying in RTI Act. There is a schedule of security and other such organizations. It is for such like cases. In addition, there are certain other exemptions, like government may exempt for certain purposes of lesser compliance burden, like requirement of giving notice, etc., to startups are mentioned by name, and other such classes of fiduciaries. Also, there is an enabling provision that in the first 5 years of the Act, a class of fiduciaries may be exempt for all or any provision of the Act. That's just in case provision kept that unforeseen situations come in, and to set the law and right. Government realizes that something needs to be exempted outright, there is an enabling provision in the exemptions. Should any ministry or department think there is such a deserving case, well, there is an enabling provision. List of house allottees sought under RTI shall be given if satisfied that it is in larger public interest, given if consented to, or not given. So yeah, the correct answer is not to be given. And the reason is the RTI Act itself is amended through the DPDP Act. Current 81J, as all of you, those who answered the A, would be aware, 81J says it is an exemption. Personal information is exempt from disclosure, but there is a qualifier. However, it may be disclosed if the CPA, if the PIO feels it is in larger public interest. And this is now, this remainder of it has been removed. If it is in larger public interest, it may feel it would be a flat bar under RTI. You can't, because otherwise the two laws would be in conflict. One would say not without consent, the other would say that. So this is, this would be the position thereafter. Here is a summing up of some of the takeaways. This was by no means an exhaustive recital of the provisions of the Act, but at this stage I thought these were illustrative. And these would have, I thought this was more designed towards getting you all to begin thinking about about the law, and also to understand it's actually very simple. And the cases and things it deals with are fairly simple, and you should start, when you look at handling of data, you should start asking yourself that question. Am I doing it right? Am I not doing it right? And the moment you start asking those questions, the answers will be fairly obvious. At the end of this course, you should have, I like it because, I don't like it because. Your mind begins to engage with the painting, with art. So this was the spirit of that little interactive session was, when you deal with data, you start asking certain obvious questions. And you will find the answers are not very difficult to find, because the law is very lean and simple. So those answers would also be fairly obvious. But, and therefore there isn't too much to wait for in terms of rules also. The more you build it into habit, you would have realized many habits would need to change, because the law would change the world for you, for the way you handle data. And there is no need for anybody to wait for a notification to start doing those things. So take for example, identify personal data and locate consent on the basis of which it is being processed. You know that consent based processing you will be required to notify as soon as practicable. Even if you don't notify, the rights will accrue. Somebody may apply to you in a right to access information, or for update, erasure, or for grievance redressal, or for a nominee. All of those would remain, or even for a withdrawal outright. If you have not inventorized your own data and tagged it as personal data and located and mapped it with the consent, you are going to face a difficulty. So don't wait for any notification. Start doing that. Inventorize both the what personal data you hold, what processing is being done, for what purpose, and where is the consent for it. And then if it is data is not needed and data is held without consent, delete it. Or if it is held without consent and if you feel it's required, reach out before the act comes into force and obtain consent. And from now onwards itself, state the purpose while seeking consent and collect only necessary data. So again, get applications comprehensively audited, all your software applications, databases, platforms, get them comprehensively audited and close all audit vulnerabilities, because tomorrow that will help you when if there's a data breach case and there is a case of did you adopt reasonable security practices, well, that audit report will come in handy. I mean, it is no insurance or whatever. Somebody may still say, no, you should have done more or whatever. But at least you've done your part. You have something to say, something tangible. Look, I'm duly audited on a regular basis. This is all reasonable security I can take on an ongoing basis. And starting now itself, enable your data principals to know information held. It's a best practice. You are holding their data. Let them know. Give them an app-based access. This is the data I hold of you. Enable them to update it. Enable them to raise grievances and close it, and to nominate a data successor. These are good practices anyhow, irrespective of the act. And nobody should really need to wait for the act to come into force to start doing that. If you do it early, you would have gained experience, you would have streamlined processes, and you would also face less adjudication, because people know you are provided, so nobody will approach anywhere. And define and minimize data access rights to ensure data security. So don't give access to anybody. Map who has access to which data, and reading, writing rights, limit all of them. So encrypt data at rest and in motion. So this is very important. We just keep data, and if you keep data just like that, it's more likely to be taken away, pilfered. And create awareness regarding fiduciary responsibility in processing data. It's a general culture. It is not our data. We are not data owners. We are fiduciaries. We hold it in trust on behalf of the person to whom it belongs. And create organizational and technical capacities. This is very important. As I said, you may contract, you may legally hold somebody else responsible, whichever agency, public or private, you engage, but the responsibility will rest with the organization. Therefore, there is no substitute for the organization creating organizational as well as some degree of technical capacities. And review all existing contracts or MOUs or arrangements with your agencies, vendors, and monitor and audit them also for compliance. So don't outsource the responsibility, because the law does not recognize such outsourcing. Law holds the one who determines the means and purpose of processing, namely the data fiduciary collectively or jointly, as the one who is responsible.